Welcome and thank you for joining Seyfarth's webinar, Overseas Discovery, Overview of Discovery Tools in the Powerful Section 1782 Statute. All participants are in listen-only mode. You are encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window. We will do our best to get to everyone's questions. If we run out of time, we will connect with you directly in the days following the webinar. For those interested in CLE credit, an attendance verification code will be read at the end of the presentation. Please write down this code. It will not be repeated and is required for CLE credit. Copies of the webinar recording and presentation materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Eddie Salcedo. Eddie, you may begin.
Today we'll be discussing the wonderful world of overseas discovery, an overview onto tools that are available, as well as a powerful tool that we have here to assist in overseas litigations in the United States, which is Section 1782. We'll be covering briefly the road that led us up to that, letters rogatory and the Hague Convention, which are used in extraterritorial discovery matters, issues which have arisen with use of both letters rogatory and the Hague Convention, and finally the centerpiece, Section 1782.
We could go ahead to the next slide. Just wanted to take a moment to recognize the sponsor of today's webinar, which is Seyfarth Shaw's International Dispute Resolution Group. This is a subgroup within the firm that has been building on decades of experience in resolving complex international disputes, including disputes between countries, companies, and various other parties. The firm has a very deep experience in cross-border litigation and international arbitration and other processes, as you can see here on the slide. And the International Dispute Resolution Group has been formed to coordinate all those efforts and to be able to better help in those disputes. So I'm very grateful to have the International Dispute Resolution Group sponsoring us today, and encourage you to visit Seyfarth Shaw's website to learn more about the group.
Okay, so when dealing with any litigation here in the U.S., obtaining discovery in your U.S. action from sources or from targets of discovery or subjects of discovery that are in other countries or territories, it's very often a difficult, cumbersome, and time-consuming process. Tools that are available for a U.S. litigant to obtain extraterritorial discovery include letters rogatory, the Hague Convention, and the possibility of taking depositions in these foreign nations. First among these is the one that's probably most familiar to litigants who have engaged in extraterritorial disputes from the U.S. is the letters rogatory. As the name suggests, it is a request being made. Specifically, the litigant will make a request of the court of which it's appearing before to issue a letters rogatory to a court in another nation where the target and the subject of discovery is, basically requesting that that court issue an order directing the subject of discovery to provide the requested discovery, be it documents, information, or depositions, to the litigant in the United States. Now, the purpose of having letters rogatory system in place is primarily to protect the sovereignty of the country where you are seeking the discovery from. If your subject of your discovery is in a foreign nation, a U.S. court basically issuing an order that this individual of a separate sovereign nation provide discovery is stepping on some toes, to say the least. And also you have the issue of enforceability. There'd be a question as to whether any order simply issued by a U.S. court would be enforceable anywhere else, and the letter rogatory itself handles that by requesting that that court that has jurisdiction in that second country issue the order directing it. Now, the party seeking this discovery can't simply make the request to the foreign court. You first have to make the request to your home court, to your judge that you're appearing before, laying forth the discovery you're seeking, why it's important, et cetera, the things we normally do. And then hopefully the letters get issued. The next step, of course, is to then having those letters transmitted to the second court, which must be signed by that judge in the foreign jurisdiction. Now, because very often the litigant in the U.S. court is not going to have standing to appear before the court in the foreign jurisdiction to present the letters rogatory, these are often transmitted either by designated agents in such nations. There are a couple of those, but most often it's transmitted by diplomatic channels. So you'll have to involve either the State Department or an embassy in order to be able to appear before that court and that foreign jurisdiction and even present the letters to be heard. That then itself becomes a hearing or a procedure before that foreign court before the court may grant it. Could involve a hearing, could involve a motion, depending on that court. As you can tell just by describing the process, this can take quite some time as there are multiple steps involved, and you're also using potentially State Department and other groups. So it's not unusual for this process to take several months and has been known to take up to a year to happen. So if you need something quickly, letters rogatory are not exactly going to set the world on fire, but it is one of the ways in which we're able to obtain it. And if we can have the next slide. The U.S. State Department does include information on serving these or obtaining these. We have the link right there on the screen or on the slide. And if you are or do have to engage in these, we do advise using that resource of looking it through, as the State Department has had many, many, many years of experience with these.
All right. So because the letters rogatory process is so cumbersome, certain nations have come together to try to streamline that process a little bit more through the Hague Convention. If we can jump to the next slide, you can see on the image there on the screen the countries that have ratified this convention. It's an international treaty. More than 60 countries have signed it. The process with the Hague Convention actually began in 1965 with an earlier Hague Convention streamlining the service of court papers and documents internationally, what we in the United States call service of process. And the Hague Convention countries said, hey, that worked out pretty well. Can we do the same thing with discovery? And that led to the Hague Convention on the Taking of Evidence in 1970. And it's been ratified by various countries at various times over the years. And again, the goal is to streamline the process, make it a little bit easier than letters rogatory. And in particular, the convention designates a centralized hub in every signatory nation where a request for documents or testimony can be served. So you're not making applications to various overseas courts, but instead there's a designated hub in each country where those requests can flow in. So a little bit easier than letters rogatory, but still can be very cumbersome in practice. And if we go to the next slide, there is a very important caveat in that the Hague Convention explicitly states that any country that wants to opt out of providing broad US-style pre-trial discovery can do so. And so many countries have signed the Hague Convention with a provision or a statement saying we're not going to honor requests for pre-trial discovery. And you can see on the slide an example from the United Kingdom where they said if a request comes in for pre-trial discovery, we're not going to honor that. And that's because that US broad pre-trial discovery is not the norm throughout the world, and many countries don't want to participate in or encourage that. So they've opted out of that, and that puts some serious limitations on use of the Hague Convention.
Some other issues and some other options that are available. If we can go to the next slide. You could have an instance where you have your litigation here in the US, you have your subject of discovery in another country, and you back channel communication, you reach out, you indicate that you're interested in obtaining this information, and lo and behold, you have a cooperating witness or a cooperating subject of discovery that's willing to provide the information. Normally, when that happens, you'll be able to either take the deposition or obtain the documents at an embassy, usually the U.S. embassy, at the overseas locations, so that the deposition can go or the discovery can go forward on U.S. rules, U.S. soil. So it'd be no different as someone coming to the United States voluntarily to testify or to otherwise provide information. Now, The witness obviously here must appear voluntarily, or the discovery must be brought voluntarily. Otherwise, if the witness or the subject of discovery is not willing to cooperate, you're going to have to go back and try either the letters rogatory or the Hague Convention, as we discussed. Next slide. Now, that being said, even if you have a willing subject of discovery, you could still run into roadblocks such as blocking statutes. So you could have a witness or a company that's willing to turn over information or provide you with testimony at the embassy or otherwise, but some nations actually prevent this. One such as in France, where there is a blocking statute which flat out prevents a French national from either providing discovery or testifying under penalty of a criminal code voluntarily. Basically, France has made it such that you need an order from a court of competent jurisdiction directing either the discovery or the testimony to take place. Another example that could limit this is the German Federal Data Protection Act. So if you're seeking information from a German company or a German individual and they're willing to provide it willingly, again at the embassy, at one of the U.S. embassies in Germany, they are still subject, all of that discovery and anything that they would even voluntarily do are subject to that Data Protection Act, which is quite cumbersome in providing information. Both of these, the French statute and the German Act, both would prohibit even a cooperating, willing target of discovery from providing the information, at the embassy in the foreign country without there being an order from a court of competent jurisdiction, once again, either the Hague or a French or German court, ordering that the discovery go forward.
Now, for litigants here in the United States, if they want discovery from overseas, they're pretty much limited to the options that we have just discussed. But if we head to the next slide, for litigants who are litigating in a country outside the United States, there's a powerful tool that allows them to come to the United States, take advantage of the broad US-style discovery, and then take that discovery to use in their overseas proceedings. And that statute is 28 USC section 1782. And you can see the text of the statute, or at least the key portion here on the screen. We're going to walk through the elements of the statute shortly, but before we get there, if we go to the next slide, Seyfarth Shaw has done an analysis of 1782 applications and court decisions on those applications. And we've seen that the use of the statute has really expanded over the past 10 years or so. And it seems to be consistent with an overall rise in cross-border litigation and disputes. So applications range from about 25 to 45 applications per year from 2012 through 2016. And after that, it really expanded and was up to 120 applications per year by 2020. But a really important point is that since 2012, federal courts have granted about 73% of these 1782 applications, either in full or at least in part. So that's an important consideration for litigants who are thinking about seeking discovery through this mechanism. You go into the process knowing that you have a pretty good chance of getting at least some of the discovery that you've requested from a U.S. court.
So what is 1782? We'll be diving into a little bit more, but first of all, it's what are the basics? What are the threshold requirements you need to meet in order to even be able to apply for relief pursuant to 1782 here in the U.S.? Well, the first one is that the target of your discovery has to reside within the district of the court that you are seeking the order from. So, for example, if you're seeking discovery from a company or individual in New York City, you would go to the Southern District of New York for such an application. Similarly, if they're in New Jersey or wherever, there you basically find the district court, which is the home of the target of your discovery, and then you make your application. Now, when it comes to corporate targets, this becomes an interesting question, which we get into a little bit, which is what specific location you need to go to, whether it needs to be the headquarter or a local branch. But from what we found, and we'll discuss in a moment, normally as long as the business is located or is running within the district that you're seeking the application from, that's the proper forum. Or if obviously the individual resides, if it's individual discovery you're seeking, as long as they reside within that district. The second prong, which tends to be the more important prong, is that the discovery you're seeking has to be for use in a foreign or before a foreign court or an international tribunal. And we'll expand upon that in a moment, what all those pieces mean. But in essence, you need to be a litigant or to be involved in a foreign either litigation or before a foreign tribunal. And the information you're seeking in aid of that is here in the United States. And finally, the application that's being made before the U.S. court for the discovery has to be made by a person or individual or party interested in that foreign proceeding. And once again, obviously we'll expand upon that a little bit on what that means, but what you're still dealing with is you're dealing with an extraterritorial request coming into the United States. So either dispute or individuals outside seeking information that's within the U.S.
So the Supreme Court has added some gloss to the statutory factors, and these factors are known in the court cases as the intel factors after the name of the Supreme Court decision outlining the factors. And the Supreme Court has held that if the statutory thresholds are met, it's not necessarily enough for the court to grant the discovery application. The court also needs to consider 4 additional factors. The first is whether the person from whom discovery is sought is a participant in the foreign proceeding. We'll talk about this a little bit more shortly, but the basic notion is that if the discovery target here in the United States is not a party to the overseas proceeding, that would weigh in favor of discovery. Second, courts are to look at the nature of the foreign tribunal and the character of the proceeding. And the big issue here is whether the overseas tribunal would be receptive to the evidence that is being provided in the United States. In other words, if the overseas litigant is successful on their 1782 application and gets the discovery and takes it overseas, is the court or arbitral panel or other tribunal actually going to take a look at that evidence? And then third, and somewhat relatedly, whether the application circumvents a foreign proof gathering restriction. And again, we'll talk about this a little bit more later, but essentially the question is whether there is a specific law on the books in the overseas jurisdiction saying that this type of discovery is not appropriate. And then finally, the fourth factor, which should be familiar to anyone who's dealt with discovery in the United States, whether the request is unduly intrusive or burdensome. And that's sort of a traditional discovery consideration about whether the requests are just too overbroad and maybe need to be narrowed a little bit to avoid any undue burden on the discovery target.
Now that we have the basics, we can dive in a little bit more to the meat to those topics that we were teasing on before. Now, while it is so far a good majority of 1782 applications are granted, there's several key considerations that need to be taken in by a party or by a litigant before they step in order to ensure that they're within that high probability of ones that are granted. The key considerations that we're going to talk about so far have been the main battlegrounds in the courts here in the U.S. as to whether or not the application the 1782 is going to apply in whole or in part to the particular request being made, and the difference between you getting your relief you seek, getting most of the relief you seek, or being excluded outright really hinges on how you frame or whether you have these considerations. Now, the first of these obviously is what is the scope of 1782 as far as who you're seeking information from. Now, the Second Circuit Court of Appeals and a number of other federal trial courts have held that relief sought, discovery sought pursuant to 1782 will entail documents that are within the possession, custody, or control of the target of the discovery. Now, this has been expanded to include not just documents or information which is physically here in the United States, but also documents or information that is being held overseas by a U.S. company in one of its branch locations in a foreign country. So here the key issue that you need to make sure is that the target of your discovery here in the US actually has that custody, possession, or control of the information being sought. That could be the difference between, a company having a branch office in a foreign nation. So you seek the relief against, the headquarters, the main company here, headquartered in the United States, and its branch happens to have the information so you can get that, versus you seeking relief from a subsidiary or a merely related entity, and that possibly derailing. And we will get into that in more detail. A specific example that has been used is that a New York company was found to have to produce information that was being held at its London branch, but there have been denials where it's not a direct control. The next prong that you really need to take into consideration is the for use prong, that prong we discussed before. Once you've made sure you've got that right target and that the company here does have control of the information, you need to make sure that you're going to be able to present to the U.S. court that the information you seek, the discovery you seek, is for use in this foreign proceeding. Here in the U.S., discovery can be obtained before litigation is commenced. That's generally referred to as discovery being obtained in aid of the litigation, usually in a situation where either the putative defendant or a non-party is in possession of key information that you need in order to finalize and fully frame the action you're about to commence. And whether or not such discovery can be used under 1782, recent decisions by the U.S. courts on 1782 cases have emphasized the need that you provide the details of your proceeding. If it is not an ongoing proceeding, but one that's about to commence, you need to be able to present to the court exactly how far along you are in commencing that proceeding. You need to make sure that the party making the application is in those final stages of maybe obtaining the one or two more pieces of information that'll be able to pull the whole thing together so the action can commence. Specifically, one district court put it as the planned proceeding must be more than just a twinkle in counsel's eye. You can't have that, I think I've got something, let me see. You really need to know, yes, I do have something, and here is the final piece that'll get us over that threshold. That brings us to the third prong, which was what exactly qualifies as a proceeding before a foreign or international tribunal. Now, the Supreme Court was slated to hear oral argument back in October of 2021 on whether or not certain types of proceedings, in particular in arbitration, qualified as a foreign proceeding or before a foreign tribunal for the use requirement, but that action was settled. So as of right now, there is an open question here in the U.S. as to that application. We have a circuit split. Currently, the Fourth and Sixth Circuits have held that a private arbitration will count as a for use in a foreign proceeding or before a foreign tribunal, whereas the Second, Fifth, and Seventh Circuits have held that a private arbitration externally does not qualify as a foreign proceeding or action before a tribunal. So in a nutshell, as of right now, it's still a little bit unsettled here in the U.S. If you are in a private arbitration overseas and your target is either in the Fourth or the Sixth Circuit, you've got some precedent that you're entitled to the relief you're seeking. And if you're in the Second, Fifth, Seventh, or possibly Ninth or other circuits that tend to follow suit, you may have a slightly more uphill battle given that precedent is there, but it is still an open question. And given the high rate of granting of these applications, it still may be worthwhile.
Now, we talked a little bit before about the intel factors, and in particular, whether the discovery target is a participant in the overseas proceeding. And as I mentioned, the Supreme Court indicated that if the discovery target is not a participant in the overseas proceeding, that weighs in favor of granting the 1782 application. And the Supreme Court's reasoning was that if the discovery target is a party to the overseas proceeding, presumably the overseas court has the authority to and jurisdiction to compel that party to produce discovery, and you don't really need discovery from the United States. Doesn't mean that you won't necessarily get discovery here, but it would be a factor weighing against the application. And just as an example of this, in the Intel case itself, the case was remanded after the Supreme Court's decision so that the district court could consider the new Intel factors in light of the decision and figure out how the factors applied in that particular case where the discovery was being sought against Intel. And the court, in considering this factor, found that Intel was a party to the overseas proceeding, in that case, an antitrust related proceeding, and that weighed against granting the discovery, and ultimately the district court denied the discovery application altogether. So it was one of the rare cases where the 1782 applicant walked away without getting anything that it had applied for. So it is an important factor, not necessarily a make or break, but a 1782 applicant is more likely to succeed if they're seeking discovery from a non-party to the overseas proceeding. Then the next issue is whether the foreign tribunal is receptive to the discovery. And typically, U.S. courts are hesitant to do a deep dive into foreign law and what foreign courts will or will not do. They often will consider expert testimony on this issue, but ultimately, unless they have a specific indication from the overseas tribunal that's overseeing the particular case at hand, the courts are likely to assume in many cases that the foreign tribunal would be receptive. So just as an example, there was a case in Canada in 2016 in which a Canadian judge was presented with some discovery that was obtained through Section 1782, and the judge wrote, "To be direct, the U.S. courts should not be under the impression that I would be receptive to the evidence being introduced at the trial." But that statement has not stopped U.S. courts from granting 1782 applications in other cases and in subsequent years involving Canadian proceedings. And again, the reasoning is that this one judge may have said that in one case, but unless the U.S. courts know that other judges in the particular cases at issue on the pending 1782 applications would reject that evidence, they're more likely to grant the application. And then similarly, with respect to circumventing the laws of the country in which the overseas litigation is pending, the courts there are not looking for just a general prohibition on a certain type of discovery or inability to obtain a certain type of discovery. For example, the fact that the overseas jurisdiction doesn't allow for pretrial discovery, there's no mechanism for that. That alone is not circumventing a foreign proof gathering restriction. What you would really need is a statute in the overseas jurisdiction saying specifically this type of document or this type of testimony cannot be produced. And only in those more limited circumstances would the court find that there was a circumvention. So just to boil it down very simply, the fact that you can't get pretrial discovery in the United Kingdom, for example, doesn't mean that you're circumventing the United Kingdom's laws by coming to the United States and making a Section 1782 application to get pretrial discovery. You'd have to have that law specifically saying these types of documents should not be produced.
Another consideration is one that's familiar to most U.S. litigants, which is the argument that discovery sought is unduly burdensome or would provide some manner of prejudice to the target or the subject of the discovery. Normally here in the U.S., you see these raised where one litigant either interposes hundreds of thousands of pages worth of requests, or requests the requests are without a set time frame, or they aren't set to specific key to specific issues in the case. So with that framework in mind, that undue burdensome framework in mind, the target of discovery here might resist the 1782 application under the same grounds, saying that the requests that are coming in would create some manner of undue burden. Now, because this is dealing with, and what we've discussed with, that one of the key factors is the laws in the originating nation where the proceeding is ongoing. A litigant may argue that it's the discovery laws of that foreign nation might impose an undue burden upon the U.S. company that's to provide this information because it has to be in compliance with it, such as if the GDPR, as we all know, has some pretty stringent privacy requirements, which would require the scrubbing of metadata, the redacting of personal information, personal identifying information, very careful review of such information before any such production was made. So in the event that someone is litigating, the litigation is ongoing in a nation that's subject to the GDPR, and they're seeking the production here in the U.S. pursuant to 1782, the target of the discovery may argue that because it's going to be subject to the GDPR when it makes its production, and depending on the breadth of the production, that it really could be an incredible expense or an incredible amount of time spent in providing that discovery. The courts in those instances have generally allowed the discovery to go forward, notwithstanding those types of privacy or other laws that might put a little bit more burden on the party producing the information than just handing it over without redaction or review. By doing and implying and employing a similar technique that was first seen here in the U.S. when e-discovery at its early dawn, when e-discovery was incredibly expensive and could be crushing. So there was the fee shifting, where the party seeking the discovery has to bear the cost of the production and has to bear the cost of the work necessary to bring the production within compliance with the foreign privacy laws, or also that there be a measurement of the expense, that the expense being made by the target of the discovery has to be commensurate to what's at stake in that tribunal or in that other litigation. So you don't want to have $2 million worth of discovery and a $50,000 fight. So the fact that there may be foreign privacy laws that the target of the discovery here in the U.S. has to comply with is not an outright bar, or doesn't automatically make it that it's unduly burdensome. However, a litigant seeking to avail itself of 1782 would be wise to target its requests, to narrowly tailor them to exactly what is necessary in that proceeding, so it could show the U.S. court that it's seeking very discrete, very specific information, how it will aid that foreign proceeding, how it will assist the litigant in that proceeding, why it's necessary, and also that it's commensurate to what's going on in that other action. And also, in the event that you do have something similar to the GDPR or otherwise, perhaps the litigant might even consider offering to pay those costs just to remove one more hurdle from the application.
We want to jump ahead one more slide, just to summarize. There are a number of tools available for litigants who are seeking discovery overseas, including the letters rogatory, the Hague Convention, voluntary compliance. But as we've seen, they can be costly and cumbersome and can come with some significant restrictions, whether it's blocking statutes or other laws prohibiting voluntary compliance, or under the Hague Convention, the opt-outs for pretrial discovery. However, for litigants who are litigating overseas, they may be able to take advantage of the Section 1782 statute if there's a discovery target here in the United States from whom they can seek discovery. And that allows them to obtain broad US style discovery that you typically can't get anywhere else in the world, and to do it in a more streamlined manner by just applying to the district court where the discovery target is found, and serving discovery requests just as you would in a U.S. litigation. However, as we've seen, Section 1782 has a number of pressure points, both in terms of the 3 factors in the statute itself and the 4 factors outlined by the Supreme Court in the Intel case. And so individuals or entities that are either intending to apply for Section 1782 discovery or who are opposing a Section 1782 request should consider those pressure points and tailor arguments accordingly.
Open the floor to any questions.
I think if we go to the next slide, we can get the CLE code out there, which is important.
The CLE code for today is SS4395. And you're not just limited now to questions. If you do have any questions, you can continue to submit them, and Owen and I will try to get back to you as fast as possible. There you have our contact information on the screen if you want to reach out or if you have any further questions on international discovery and the various tools available to you.